Hello students, let us learn the fifth chapter of your political science textbook today. Judiciary. When you read a newspaper, you come across certain articles that mention the work of courts in our country. These courts are needed to uphold the rule of law. Every person is equal in the eyes of law, and if anyone violates the law, a particular set of fixed procedures have to be followed. To enforce these rules, India has its own judicial system. Under this system, there is a mechanism of courts that people can approach if they come across cases of law being violated. The judiciary is an organ of the government. It has a crucial or a very important role in the smooth functioning of Indian democracy because it is independent. What does it mean when we say the judiciary is independent? It is the ability of courts and judges to perform their duties free of influence or control by other actors, whether governmental or private. So, what is the role of judiciary in democracy? A court needs to make decisions regarding a number of cases. It can decide varied matters like how the water of a river will be shared between two states, what punishment should be awarded to a corrupt politician, or if physical punishment needs to be banned in education institution or not. The work done by judiciary is divided into three: dispute resolution, judicial review, enforcing fundamental rights, and upholding the laws. Let us find out what all these are. Dispute resolution. The Indian judicial system provides a mechanism to resolve any dispute that can arise between government and citizens, between the state and the central government, and between two states. The judicial system resolves all these disputes. Now the second one is judicial review. The judiciary is considered as the final interpreter or explainer of the Indian Constitution. It has even got the power to strike down or abolish a law passed by the parliament if it believes that there was a violation of the constitution in that case. This process is known as judicial review. And the third function of the judiciary is enforcing fundamental rights and upholding the laws. If a citizen believes that his fundamental right has been violated, in that case, he can approach the High Court of the respective state or the Supreme Court. For example, in class 7, you had studied the laborer's case who had got injured. Since several hospitals refused to admit him, his condition had worsened. He filed his case in the Supreme Court. The judges ruled that Article 21 provides every person the right to live, which is a fundamental right. It also involves the right to health. Further, it directed the West Bengal government to pay the compensatory amount to the laborer. It also asked the state government to come up with a blueprint regarding primary health care where the patients could be directly treated during a period of emergency. Now let us learn some details about the high courts in our country. The first high courts were set up by the British in the presidencies of Madras, Calcutta, and Bombay in 1862. The Delhi High Court was established in 1966. Currently, India has 25 high courts. While several states have their own high courts, the states of Punjab and Haryana have a common high court at Chandigarh. The northeastern states such as Assam, Arunachal Pradesh, Mizoram, and Nagaland have a common high court located at Guwahati. Telangana and Andhra Pradesh have separate high courts since January 1st, 2019. For better accessibility or for the people to reach easily to the courts, a few courts have their benches in different cities. For example, the Maharashtra High Court has its bench in Nagpur apart from Mumbai. Similarly, the Guwahati High Court represents states such as Nagaland, Arunachal Pradesh, Mizoram apart from the state of Assam. We have been talking about the independence of judiciary. What is an independent judiciary? Let us find out. Suppose that a powerful politician has illegally occupied a land that belongs to a family. Within that judicial system, the politician has the power to appoint or dismiss any judge. It is clear that the judge may be partial in this case. He may favor the politician fearing a dismissal. Since the politician has control over the judge will be unable to take an independent decision. Since there is a lack of independence while making decision, the judge will be forced to decide in favor of the corrupt politician. Although there have been cases of powerful and rich people trying to influence the judicial process through various means, this can be prevented. The Constitution of India clearly mentions that the judiciary in India has to be independent. The separation of powers is one of the aspects of this independence. It means that the two branches of the government, which are the executive and the legislature, are not supposed to interfere in the work and decisions of the judiciary. The courts in India do not function on behalf of their governments. The courts are not under the control of the government. To ensure that this separation works well, it is important that the judges of the Supreme Court as well as High Court are appointed without any interference from the branch of the government. The removal of a judge is very difficult once he has been appointed to the office. Since the judiciary in India is independent, it ensures that there is no misuse of power by the executive and the legislature. The judiciary has an important role in protecting the fundamental rights of a common Indian, since they can approach the courts at any level if they feel that their rights are being violated. Now let us find out the structure of Indian courts. In our country, there are three different levels of courts: the district level court, the High Court and the Supreme Court. Let us start with the district level court. At the lower level, there are a number of courts. However, at apex level, there is only one court. District courts or subordinate courts are the ones where most of the people interact. The subordinate court is known by different names. It includes Court of District Judge, Trial Court, Chief Judicial Magistrate, Civil Judge, etc. These courts are located at a tehsil or at the district level or in towns. They hear different types of cases. Each state in India is divided into different districts. The courts located in these districts are presided by the district judges. The next level is the High Court. Every state has a High Court. Not all the states, we have got only 25 High Courts. The High Court is the highest court of that particular state. The High Courts of India are the highest courts of appellate jurisdiction in each state and Union Territory of India. And the third level is the Supreme Court. The Supreme Court is India's topmost court at apex level or the highest level. It is located at New Delhi. The Chief Justice of India presides over this court. The decision made by the Supreme Court is binding on all other courts located across the country. The different levels of courts in India are connected to each other. The judiciary system is integrated or combined in our country. It means that the decisions made by the high courts bind the lower courts as well. Another way to understand this feature is via the appellate system that still persists in our country. It means that a citizen has the right to appeal to a high court if they are not satisfied with the judgment passed by the lower courts. Let us understand this by considering a case, State of Delhi Administration versus Lakshman Kumar and others, 1985, by tracking it from the lower to the higher court. Lakshman Kumar had married Sudha Goyal in February 1980. In December 1980, Sudha died due to burns. Her family filed a case in the lower court charging that her husband and in-laws were responsible for her death. As this case was being heard in the trial court, 4 neighbors were called as witnesses. They stated that they had heard Sudha screaming the night before her death and they rushed into the house. They found Sudha in flames. They immediately wrapped her in a blanket and a gunny bag and extinguished the fire. Sudha told them that her mother-in-law had poured kerosene on her and her husband had lit the fire. While the trial was going on, these witnesses told the court that Sudha was subject to different types of torture from her husband and in-laws. They were demanding dowry such as cash and a scooter from her family on the birth of the first child. On the other hand, Lakshman and his mother in their defense had stated that Sudha's sari had caught fire accidentally as she was heating the milk. On the basis of evidence, the trial court convicted Lakshman, his mother and his brother-in-law Subhash Chandra and awarded them the death sentence. In November 1983, the three accused appealed against their sentence in the High Court against the verdict of the trial court. After hearing the arguments of the lawyers from both sides, the High Court concluded that Sudha died due to accidental fire which had taken place because of the kerosene stove. Hence, all three accused were acquitted. They were freed from the criminal charge by the verdict of not guilty. In 1985, Sudha's family appealed against the decision of the High Court in the Supreme Court against the acquittal of all the three accused. The apex court, the Supreme Court, heard the arguments from both sides and reached a conclusion which was different from that of the High Court. Lakshman and his mother were declared guilty according to evidence. However, his brother-in-law was declared not guilty because there was no evidence against him. The accused were sent to prison for a lifetime by the Supreme Court. From this example, it is clear what is the appellate jurisdiction of the courts. If you are not happy with the decisions of the lower court, you can go to the higher court. Even if you are not happy with the decision of the High Court, we can go to the Supreme Court. This Sudha Goyal case of dowry death is a violation of criminal law and it is considered as a crime against society. Apart from criminal law, the courts also have to deal with cases under civil law. So we can say that we have two types of laws. One is criminal law and the other is civil law. Do you remember a new civil law being passed to protect the rights of women against domestic violence? Protection of Women Against Domestic Violence Act, which came into existence in 2005. In the last chapter, we studied that. Now let us find out what is the difference between civil law and criminal law. Let's start with civil law. Civil law deals with any injury or harm to the rights of individuals. Example, divorce cases, land-related matters, purchase of goods, etc. Only the affected party can file a petition before the relevant court. If the matter is related to rent, either tenant or landlord can file the case. The court provides relief that has been asked for. For example, if the case is between landlord and tenant, the court can either order to pay the remaining dues or to vacate the flat. Now let us find out the details of criminal law. Criminal law deals with acts or conducts that are identified as offences. Example, murder, harassing a lady for dowry, theft, etc. Firstly, a first information report (FIR) has to be filed before the police officials who will investigate the matter. After that, a case is filed in the court. If the accused is proven guilty, then he is sent to jail. We have been talking about the courts and the different types of laws. And the question here is, does everyone have access to courts? According to the principle, every citizen of India has the right to access the court. It simply means that every person has the right to get justice with the help of the courts. It has already been explained how the courts play an important role in protecting the fundamental rights of citizens. If a person finds out that her right is being violated in any form, then she can approach the courts at any level in order to get justice. While the Constitution states that everyone has access to courts, in reality, the poor people have always found it difficult to access them. Legal procedures requires lots of time, patience and money. For a poor person who is not even capable of reading and is a daily wage laborer, the idea to visit courts in order to get justice seems to be out of his reach. Keeping such situations in mind, the Supreme Court in 1980s devised a mechanism called PIL, Public Interest Litigation, so that a poor person's chance to get justice be increased. It allows any organization or individual to file a PIL in the Supreme Court or High Court on behalf of the people whose rights have been violated in the past. Due to this step, the legal system got simplified. Even a telegram or a letter addressed to the High Court or Supreme Court could be treated as a public interest litigation. In its earlier years, activists took the help of PIL to secure justice in several issues. A few of these were for matters related to securing the release of those prisoners who were kept in jail even after their punishment term was over, and the release of bonded laborers who were working in inhuman conditions. For a common citizen, access to court means access to justice. Courts play a critical or a very important role in protecting the fundamental rights of the citizens. During 2001, several Indian states such as Odisha and Rajasthan had to face severe drought. Due to this, there was an acute shortage of food for millions of people. Although the government's godowns were full of grains, they were being eaten by rats. In such a situation, an organization named People's Union of Civil Liberties filed a appeal in the Supreme Court. It stated that Article 21 that guarantees right to life also includes right to food. The excuse of the states that there was not enough food was wrong, as their godowns were overflowing with grains. The Supreme Court ruled that it is the duty of state government to provide food to each person because it is the fundamental right of every citizen, right to food. Hence, the government was directed to provide grains at cheap prices at the government ration shops, generate employment and provide midday meals to school-going children. The Supreme Court also appointed 2 food commissioners who had to report about the implementation of these schemes. Although the courts act to protect the rights of common people, there also have been cases due to which one can believe that these judgments are against the interests of the common people. For example, those who work for issues regarding right to shelter for poor people believe that current judgments related to evictions are wrong. Another issue that is a barrier in a common person's pursuit of justice is that the Indian courts take a number of years while hearing a case. The extended time that courts take to deliver judgment is characterized as justice delayed is justice denied. The courts take such a long time to resolve the cases because of the lack of number of judges in our country. This table shows the number of judges in India at present. In Supreme Court, 34 sanctioned strength. Working strength is only 32. 2 vacancies there. In High Court, 1098 sanctioned strength, but the working strength is 687. 411 vacancies. In the District and Subordinate Court, 22,644 sanctioned strength and working strength is 17,509. 5,135 vacancies. Despite certain shortcomings, the Indian judiciary has played a key role in democratic India. Since India's independence, judiciary has acted as a check on those legislative and executive powers. That's all the chapter. Now read the chapter well and watch the video again. Then find out as many one-word questions and answers as possible and copy that to your political science notebook. Don't forget to send that to my WhatsApp number before 5 p.m. today. Thank you for watching.